Thank you. First of all, I want to thank Wachtell for hosting us, and especially Trevor. He is a great friend of the project, and we are incredibly grateful for his support. And obviously, I want to thank Eugene for offering to give this presentation, and for everyone for coming today. I serve as director, the founder and director of the Lawfare Project, which is a not-for-profit based here in New York, which is dedicated to monitoring and exposing and combating the phenomenon of lawfare, which is the use of the law as a weapon of war. Now, Eugene's going to talk. He's going to give a wonderful objective analysis of the international law that applies to what we call the settlements in the West Bank or Judea and Samaria. But I think also in light of the recent terror attacks in Boston, that it's particularly important that we also focus for about 5 minutes on another tactic used by lawfare proponents, and that is the filing of frivolous and malicious lawsuits against those in the counterterrorism community who have been working to expose the root causes of terrorism and who are working and who are brave enough to write openly and speak publicly about the threat of Islamist terrorism. And there are plenty of examples of this, and many of you probably have heard of the Islamic Society of Boston. This is a mosque/community center that was actually attended by the younger Boston bombing suspect, where the imam is not only linked to the Muslim Brotherhood, but he's known for giving sermons that incite violent jihad against the West. Now, I'm not saying that there's any connection between this imam and the Boston bombing suspect, but what's to note here is that when Fox News and the Boston Herald and 17 other media outlets were writing articles about the ISB and about this mosque and the fact that they were receiving funds from Saudi Arabia, from the Wahhabi regime of Saudi Arabia, they were sued by ISB in a frivolous lawsuit that was designed to shut them up and to intimidate them into silence. Now, what happened? After 2 years of discovery, as most people here know, that if you're accused of defaming someone, you have the opportunity in a court of law to prove what you're saying is true. Now, right before the discovery process, where the defendants could discover the financial documents of ISB and go forth and prove what they were saying, ISB mysteriously dropped the case. We have, for example, ICNA, the Islamic Circle of North America, which has physical ties with Hamas, which is a designated terrorist group in this country. It has financial ties to the Muslim Brotherhood, had a family fun day targeting children in Texas, where they arranged for children and their families to come to a Six Flags park. And when American citizen and activist Joe Kaufman staged a peaceful, lawful 10-person protest against ICNA, he was sued. But not by ICNA. He was sued by 7 Dallas area Islamist organizations whom he had never mentioned, whom he had never spoken about, and obviously that suit was thrown out of court because they had lacked any type of standing. And of course, we have one of the largest proponents of this type of lawfare aimed at silencing and intimidating the counterterrorism community is CAIR, the Council on American Islamic Relations, which is an unindicted co-conspirator in a Hamas funding trial. It was called, quote, a fundraising arm for Hezbollah by former Congressman Cass Ballinger. And of course, Cass Ballinger was sued by CAIR after he spoke to the media about the Council on American Islamic Relations, and the judge threw that out of court because obviously the congressman was acting within his public duties. Now, even though most of these lawfare lawsuits fail, the defendants still lose in time and money spent defending their rights, and it has created a chilling effect within this society. There is a lack of discussion about the root causes of terrorism. There's a fear of being called Islamophobic if you talk about Islamist terrorism, and that results in complacency. We're all very surprised that this happened in Boston, when in reality we should all be very thankful that this is the first time since 9/11 that we had a successful attack. And, well, not thankful for the attack, obviously, but thankful that nothing has happened before. And we're all in a state of confusion. What is terrorism? Most people, after 9/11, you walk downtown, take a survey, ask 10 people how to define terrorism. I guarantee the majority of those people will not be able to define the word terrorism. Our president, for example, said terrorism is when anybody blows up bombs in a public place. Unfortunately, that's not an accurate description of the crime of terrorism. And why is that? It is because there is a coordinated effort, both on the international level and here within the United States, to create this confusion. For example, last year, Congressman Peter King held the first of a series of hearings in Congress about homegrown radicalization. Peter King put Somali parents on the stand who testified with tears in their eyes about how their American-born Somali children were being targeted within our borders by Al-Qaeda. They were being radicalized, they were being recruited, they were being flown across the border to Pakistan and to Afghanistan. They were being trained abroad. Peter King was called an Islamophobe. Publications like the HuffPo, the Council on American Islamic Relations, the New York Times called Peter King an Islamophobe because he was advocating that we protect the human rights of American Muslim children. The same thing happened with New York City Police Commissioner Ray Kelly. He appeared in an incredible documentary film called The Third Jihad. It was co-produced by a Muslim American doctor, Dr. Zuhdi Jasser. And Ray Kelly was also called an Islamophobe for teaching Americans about the threat of homegrown radicalization. And who was one of the parties who called for Police Commissioner Ray Kelly's resignation? The Council on American Islamic Relations. In the meantime, the Lawfare Project is the only organization that has exposed the fact that Hezbollah and Hamas are both unlawfully currently airing their television programs within the United States and Canada. And we have an internship program. One of our interns, Ina, are you here? Can you stand up? While doing research for the Lawfare Project, she is the one who discovered that Hezbollah and Hamas were brazenly advocating through a company called Nilesat IPTV that they're broadcasting their television shows within this country, and yet the counterterrorism community has been raising awareness about this, and the Attorney General's office hasn't done anything. Homeland Security hasn't done anything. Finally, I just want to mention also where this is coming from. Where is the intimidation against our counterterrorism community coming from? Well, every year for the past 12 years, the United Nations Human Rights Council has passed a resolution that attempts to outlaw what they call the defamation of religion in international customary law. One of these resolutions, UN Human Rights Council Resolution 719, is a particularly Orwellian document. Not only does it attempt to make criticism of religion illegal, but it also says that thinking thoughts, ideas that are deemed xenophobic, should also be a violation of international law. Now, one of the more recent Human Rights Council resolutions is 1618, which follows this long line of attempts to criminalize the defamation of religion. And it criticizes the negative projection of religion, and it targets specifically the counterterrorism community, talking about Islamist terrorism in the media. Now, who was the co-sponsor of this UN Human Rights Council resolution? The United States. This past December, Secretary of State Hillary Clinton had a 2-day closed-door meeting with the head of the Organization of the Islamic Cooperation, which is a 57-member voting bloc at the United Nations General Assembly. Afterwards, the meeting was closed to the media. Afterwards, they came out and announced the implementation of this resolution. What has followed? Seasoned FBI officials have been fired because their presentations are deemed Islamophobic. The words jihad and Islam have been redacted from all U.S. counterterrorism training manuals. And then you have something like Fort Hood, where it is classified as workplace violence and not terrorism. And obviously the biggest victims of this are the families of the victims at Fort Hood, because they were denied the ability to recover for damages under the terrorism statute. And of course, what was not entered into evidence was the fact that Major Nidal Hassan's bank account was emptied by his brother and the funds were given to Hamas, a designated terrorist group. This was not entered into evidence in the case because it was not a trial of terrorism. And we now have CARE and ISNA, the Islamic Society of North America, which are both Muslim Brotherhood affiliates. The Muslim Brotherhood, as you know, birthed Al-Qaeda, birthed Hamas, advising our government on what counterterrorism policies we should pursue within our borders. Now, the Lawfare Project is committed to seriously examining and exposing these issues, amongst others. We have an article that just came out in the Fordham International Law Journal that goes into much further detail about what I was just talking about. Lawfare, the War Against Free Speech, is also a book that we just released that I co-authored. It's available here for sale. It's $10. And it's the reason why we wrote it, and I was born in Canada, and I'll end with this, is as a Canadian, I came here to the United States to practice law because I have a deep respect for the American Constitution, but I was extremely troubled when almost every month I would get a phone call or two from members of the media or from American citizens asking me if blasphemy was a crime in this country, if you could write and speak publicly about militant Islam and terrorism and its sources of financing. And so we wrote a book that basically examines what your protections are under the First Amendment. You don't have to be a lawyer to understand it, and I highly recommend anyone in here who's interested about the subject to pick it up. So with that, I will introduce our next speaker. The Lawfare Project hosts, along with law firms like Wachtell, various CLE accredited events, and which reminds me, if you want CLE credit, please do not forget to sign out. The sign-out sheets are over there. This is a particularly important event, and I'm a big fan of Professor Kontorovich because he has a knack for taking very complicated issues and making them very accessible. He has a very accurate presentation. I believe we have the PowerPoints duplicated within your handouts here. He will speak for about 55 minutes, and then we will open up to a Q&A period. Thank you very much.
Thank you all for being here today and for taking time out for lunch to learn about this important subject. Let me frame the scope of our discussion today. We are talking about the legality under international law of the Jewish presence in the West Bank and the Jewish civilian communities known as settlements in the West Bank and Golan Heights. The mainstream view amongst international lawyers, reflected in the press, is quite easily described. It's that Israel has no right to be in these areas in any way, and that all Jewish civilian presence in these communities is a war crime. And this view is repeated without much analysis incessantly in the media. Any mention of Israeli settlements in the West Bank will be accompanied in the news with the qualification, which are illegal under international law. Israeli settlements which are illegal under international law. Notably, none of these references suggest that there could be some settlements that are legal, other settlements that are illegal, that it might be a fact-specific inquiry. Rather, the generally accepted view is that there is a blanket prohibition on Jewish civilian presence in parts of in the West Bank. And that's the view which I'm going to discuss today. And I'd like to start by pointing out that when the illegality of the settlements is noted, it's very rarely mentioned which provisions of international law they're illegal under. And that's what we're going to look at today. We're going to look at binding sources of international law and actually look at the text, look at how they've been applied in the past, look at how they've been applied to other cases, and see what international law, as I think fairly and objectively construed, says about the situation. Now, let me say a few words about why I need to speak for 50 minutes. Because I could do a 1-minute version of this, in which I would rattle off a train of United Nations resolutions, Security Council resolutions, General Assembly resolutions, in particular General Assembly resolutions, Human Rights Commission resolutions, a very impressive sounding list of resolutions, which all quite squarely conclude, in accordance with the mainstream view I just mentioned, that Israel's presence in these territories and the civilian presence there of Jews is entirely illegal. And this might be impressive because, after all, the General Assembly is international, and they're making legal claims. So isn't that international law? But that's not how international law gets made. And for those of you who, most of you, I take it, work in the real world, so let me just say a thing or two about where international law comes from. Treaties and custom. These days, mostly treaties. But nations have to agree to be bound. The General Assembly is not a legislature for the world, and it does not have the power to make legal decisions. It's not like Congress. Now, why is it not like Congress? Not because we don't like what it says, but because the Charter of the General Assembly does not give it lawmaking power. For nations to be bound by rules made by an international body, they have to first delegate to that body the authority to make those rules. The General Assembly does not have that authority. Rather, it is purely a deliberative body. It's a schmooze fest. It's where politicians go to schmooze. The Security Council does have certain powers, but the General Assembly, they can express their views, but they are not legally binding. So that's why we need to speak a bit longer. Now, if they were legally binding, the question would actually be quite simple. Because since the General Assembly has actually decided that Zionism is racism, that would presume that the Jewish state would be illegitimate regardless of the boundaries, and that the quibbles about the boundaries are really not central. Now, many people in this context also cite the International Court of Justice advisory opinion concerning defense, which similarly is not a source of binding legal authority. It sounds better. It's the International Court of Justice, which people often mistakenly refer to as the World Court. Again, the International Court of Justice, by its own charter, only has jurisdiction to make binding legal determinations to parties that submit to its jurisdiction. This was not such a case. It was a case of an advisory opinion, which, as its name suggests, is of only persuasive authority. And you could read its opinion. You could read the opinion and see yourself how much you're persuaded. The opinion is very long, which might suggest at first that it has lots of analysis, but that's just the style of the International Court of Justice, and because every other page is French. In fact, the analysis is quite short on this point, because who are they providing advice to? It's important to know who are they advising with their advisory opinion. They were advising the General Assembly, who we just mentioned. The General Assembly had submitted the following question, and it shows that the General Assembly knew, like all good litigators, that how you frame the question is as important as the answer. The question was, bearing in mind Israel's ongoing illegal occupation of Palestinian territory, with all its detrimental consequences, implications and consequences, what are the legal consequences arising from the construction of the wall? So not much analysis was needed to answer that question. Now, so we are looking for authoritative sources of international law, and that's going to be a little bit frustrating because there aren't so many. Now, this is not just because it's the Israeli-Palestinian conflict. In general, international law is vastly underdetermined compared to municipal law. There's not a federal register of tens of thousands of pages of regulations being constantly promulgated. It's thinner, and one has to look a bit more closely. So before we turn directly to the question of settlements, which is really a question about the Geneva Convention, it's worth saying a few words about the history of the territorial claims to Israel and the West Bank. And I'm not going to go into who was there first, but it's pretty cool because we can cover 400 years in about 40 seconds. Up until 1917, if you were to ask anyone in the world who was the sovereign of this territory, it was the Ottoman Empire. They were the sovereign of the entire area and the area around that area. The Ottoman Empire collapses in World War I, and the newly formed League of Nations, of which Turkey is a member, and the winning powers are a member, the newly formed League of Nations takes upon itself the duty. One of the duties of the League of Nations was to create an international supervision system for the former Ottoman territories until they could become independently functioning states, what we today would be called state building. Instead of just having countries take upon themselves state building, which could have potential abuses, this would be supervised by the League of Nations. How did the League of Nations get this power? It's not just something they assumed. This was actually in the charter of the League of Nations. It was one of the specific tasks with which the League of Nations was charged. And the system for implementing this was called the mandate system. The mandate system. Today, most of us will only have heard, unless we take a particular interest in this, of the mandate for Palestine, otherwise known as the British mandate, quite inaccurately. In fact, there was a system of mandates, over a dozen, around the world. It was not just former Ottoman colonies, former German colonies. There was a system, a very complicated and integrated system of mandates, of which the Palestine Mandate was just one. And this is what the Palestine Mandate that was approved by the League of Nations, this was what it looked like. And I would just note that there were some other, it was part of an integrated system of mandates in the Middle East, with Syria, from which Lebanon was also formed, being a mandate for the French, and it doesn't fit on this map, but Iraq was a mandate for the British. So there were actually two British mandates, the mandate for Mesopotamia. If you examine the proceedings of the League of Nations, the 99.9% of this discussion was about the Syrian and Mesopotamian mandate, because that's where the oil was. The Palestinian mandate was considered rather uncontroversial. So this is what's supposed to happen with this Palestinian mandate. It's supposed to be a national home for the Jewish people. And what's that principally mean? That means for close settlement by the Jews. In other words, it suspends the Turkish ban on Jewish immigration. Ottomans had traditionally restricted Jewish immigration into Palestine. That is now suspended to create a Jewish national home in this territory. Now, there's another provision which says that the mandate could be suspended on its eastern portion if there's not enough Jews, basically, for the whole thing. And the British immediately exercise this, and they create this thing, which is now known as the Hashemite Kingdom of Jordan, exercising their power under Article 25 of the mandate. So what are we left? Leaving the blue part as mandatory Palestine under these particular provisions. So as you can see here, we're in the 1920s, and the borders of mandatory Palestine are quite clear, and clearly there's no such thing as a West Bank or a Gaza Strip in them. Now, so this is pretty good, right? This suggests that based on the League of Nations mandate, Israel's title to the West Bank is as strong as its title to Tel Aviv. So if you want to criticize Israel's claims to the West Bank, you have to attack the mandate. And indeed, people do attack the mandate. The legitimacy of the mandate. Right? You have to say that the mandate we have to throw out. There's a strong rule in international law, iusi potestatis, that you go with pre-existing borders, even pre-existing colonial borders, which these aren't. So when the International Court of Justice is adjudicating Latin American territorial disputes between two independent Latin American countries, they're actually deciding this by maps that they dig off of sunken 15th century Spanish galleons. So even the colonial origin of borders is not disqualifying under the iusi potestatis. And here are very recent, very clear borders, which are presumed to continue. So you have to really attack strongly the League of Nations mandate. And that's what people do. They say, mandate, schmandate. What authority does the mandate have today? There's no League of Nations around. They decided this at San Remo. Isn't that like a bottled water company? Why should anyone care about the borders of the League of Nations? And that's what you have to say, because so far we're doing pretty good. America does not have a League of Nations mandate to explain its territories. So a League of Nations mandate is pretty good. It's better than most countries have as the basis of their territory. So there's an argument of illegitimacy. And there are really two answers to that. There's two answers. One is legal and one is practical. First of all, let me cite to you two people who make this argument against the mandate. One is dead and one is living. So Saddam Hussein argued against the mandate because when he invaded Kuwait, he didn't invade it without a claim of right. Kuwait was at one point historically part of Iraq. It was not for reasons of British policy, included by the League of Nations in the mandate for Mesopotamia. Saddam Hussein says, why should we be bound by the mandate borders? What's the League of Nations to us? No country in the world concurred with that view. Now, Lebanon was partitioned from Syria to create an Arab Christian country next to an Arab Muslim country, much like Jordan was partitioned from Palestine to create an Arab Muslim country next to a Jewish one. And if you look at the map on President Assad's wall today, there's no Lebanon, because this was a decision of the mandatory, later ratified by the League of Nations itself. But Assad says, why should I be governed by mandate boundaries, by decisions of the mandatory? What's the mandate to me? And indeed, under this pretext, Syria occupied Lebanon for several decades. No country in the world agrees with this view. So if you're actually arguing against mandatory boundaries, the impact goes far beyond this little issue with the West Bank. It actually calls into question, if the mandatory boundaries are invalid, it calls into question the borders of Turkey, Syria, Lebanon, Israel, Egypt, Saudi Arabia, Iran, everything. Every border in the Middle East is the product of the mandate. So you need a very kind of a form of special pleading calling into question the mandate for Palestine, but not the mandate system in general. That's a little bit awkward. But also the mandates are not an anachronistic thing just because the League of Nations is not around. Indeed, the United Nations directly inherited the existing mandates that were not terminated. The United Nations took over. They rebranded them as the Trusteeship Council, like they rebranded many things. They changed the Permanent International Court of Justice to the International Court of Justice and so forth. But they took over those. And indeed, the United States was itself a mandatory power, a trustee of several now independent countries well into the 1990s. And Article 80 sub 1 of the UN Charter specifically validates the legitimacy of mandates issued by the League of Nations. So this is not something that we have abrogated, that we've grown past. Mandates are very much recognized by present international law. So this is pretty good as a start for boundaries. Now, of course, Britain announces that it is not going to stick around until the completion of the mandate after World War II. It's tired and wants to go home. And it's clear that this will result in war, and the United Nations famously proposes the partition plan. What is the status of the General Assembly partition plan for Israel? So its status, obviously, is recommendatory. That is to say, they held hearings. They said, this is what we think is fair. We are the new United Nations. We have a lot of legitimacy. And under the basic principles of international law, if all the sovereign parties had agreed, it would be binding. Sovereigns can bind themselves. They can waive their rights. But clearly, the General Assembly does not have, and did not purport to have, the power to draw sovereign boundaries, abrogate mandates, and so forth. So this was many people mistakenly think that the General Assembly, with its partition plan, created Israel or authorized Israel. It's really far from the case. They actually offered Israel half the territory remaining under the mandate, and had all the relevant parties agreed, that actually would have been the borders today. But indeed, it's not. So finally, as a result of the War of Independence, this is the first time we see these boundaries emerge of the green line, the West Bank, what's now called occupied Palestinian territory. And you see that the term occupied Palestinian territory is really quite accurate, because it's territory of the League of Nations mandate for Palestine, which was occupied since 1949 by Jordan in the West Bank and Egypt in the Gaza Strip. So this is the first time these borders appear on the map. And I want to stress a few things about these borders. As you can see, they do not coincide with any previous demographic, topographic, linguistic, political, administrative, or territorial boundaries. They are simply the furthest extent of combined Arab arms in their attempt to prevent the creation of a Jewish state in mandatory Palestine. Right? Egypt invades from one side, Jordan, Iraq, and some other countries invade from the other side, and they have a Molotov-Ribbentrop type goal of meeting somewhere in the middle and dividing the territory along a yet-to-be-agreed-on formula. Right? Their goal, prevent the creation of a Jewish state. This is how far they were successful. And so we see, 1949 to 1967, this territory is occupied by Jordan in the West Bank and Egypt in Gaza, two totally different countries. How many UN resolutions were there condemning the occupation of Palestine 1949 to 1967? So I think it's obvious that there was zero, but what I found maybe surprising, there wasn't even a proposed resolution that failed. It was really not an issue. Not an issue. So what can we see from this map? So Jordan is occupying these territories. These are often called the 1967 borders. The 1967 borders. That phrase is inaccurate in two ways. First of all, they were not created in 1967. They were created in 1949. They were obliterated in 1967. And they're not borders. They're armistice lines. We'll explain the difference in a minute. So where did we get this green line from, by the way? So an Israeli colonel sits down with a Jordanian colonel, and they draw two lines on a map representing where their armed forces were, so they would try not to shoot at each other during the armistice. And the Israeli colonel happened to have a green marker. Now, so if you believe in the green line, if you believe that the legal regime changes when you cross this invisible line, then it's important, if you think the green line is a genuine concept, then this is part of the concept. This was provision 1, I believe, of the armistice agreement. It is not to be construed in any sense as a political or territorial boundary. That is about as clear as you can say that this is not a border. Why? Because of the next part of the sentence. Both sides retain a right to try to conquer the rest of it. That's the only thing they could agree on. Israel says the rest of it's ours, we're going to try to get it back. And Jordan says, yes, we agree, the rest of it is ours, we're going to try to get it back. And other than that, they didn't agree on much. So imagine a little asterisk next to the green line. And under the asterisk is this sentence: not to be construed as a territorial political boundary. So it's not 1967, and it's not a border. Other than that, it's a pretty accurate description, 1967 borders. Okay, now, let's go back here. So here's the important little point. What is the legal status of these territories, 1949 to 1967, when they are under the occupation of two different Arab countries? What is their legal status? So let me submit a couple possibilities. One possibility is that they are Israeli sovereign territory under the belligerent occupation of various Arab countries. Maybe. I don't want to sell that to you. Here's another possibility. Another possibility is it is not Israeli sovereign territory. It is disputed territory in which no one has yet perfected sovereignty, and Israel has a legal claim. That sounds a very technical distinction, but what's the difference? Under one view of sovereignty, you actually need to control the territory at some point for it to fall under your sovereignty. So even though Israel is the success, the argument for the first view, that it's Israeli sovereign territory, is Israel is the successor state to the League of Nations mandate. Don't mind that it has a different name. They just decided on the name Israel at the last minute, but they could have called it Palestine. So Israel is the successor to the mandatory Palestine, and this is within the borders of mandatory Palestine. It's all part of the same thing. The other argument is, well, Israel never actually succeeded in asserting its control in these areas, so Israel has a claim of title based on the mandate. Now, what's Jordan have? Jordan doesn't have a very good claim to title. No countries in the world really recognize Jordanian sovereignty in this area. So there's a dispute over territory between Israel and Jordan. Israel has the better title, but it has yet to perfect sovereignty. That's maybe a little gap, but I think it's important to stress why we don't know the answer to which one it is. Because international law is underdetermined. Right? You cannot open the Federal Register of International Law and find an answer to a question: what is the status of an international trust territory in which the trustee, the mandatory, abdicates before the completion of the terms of the trust, and different parts of the territory fall under hostile occupation of various countries contrary to the terms of the trust? There's no answer to that. And if I were to emphasize one point today, if you don't believe anything the rest of what I'm saying, which you should because it's all true, whenever someone tells you international law clearly says about the Israeli-Palestinian conflict, ask, from where do we learn that out? From what case do we learn that out? What's the precedent? Where does it clearly say that? What were the prior cases? Because usually the answer is just not so clear. Not so clear. So Israel has either sovereignty or a superior claim of title to these territories. Now let me note an important distinction here. When Israel takes back the West Bank and Gaza Strip and the Golan Heights and the Sinai in the Six-Day War, the legal status of the Golan Heights and Sinai is obviously going to be quite different from that of the West Bank. For the West Bank, Israel has a very strong argument. They say, look, this was part of mandatory Palestine, and it was just squatted on by the Jordanians for 19 years, but that shouldn't change anything. The argument for the Golan Heights is going to be a little bit trickier, because Golan Heights, if you were to, so a useful exercise, which I've conducted, is to look at books, to really figure out what's going on with the West Bank. It's not useful to look at books written since 1967, because then everyone knows how the story ends. Look at books written, international law books written before 1967, and see how did they describe this territory. So I have conducted this exercise. Generally, nobody says it's Jordanian territory. Nobody says it's Palestinian territory. And actually, nobody says it's Israeli territory either. It would be odd to say it's Israeli territory because Israel's not there. What do they say? They say it's disputed territory. It's one of these post-war messes, like the Kashmir and Korea. Those are the two analogies invariably used. Kashmir and Korea. Because remember, both Koreas claim the entire peninsula, so one of them is illegally occupying the other, but it's hard, you don't know which one. So those were the comparisons that were made. If you asked anyone in 1967, who's the Golan Heights belong to? They'd say Syria, of course. Who's the Sinai Peninsula? Egypt. This was uncontroversial. So Israel's claim to these territories must depend on some other principle, and that principle would have to be defensive conquest. Defensive conquest. This is weaker than the League of Nations mandate. Why? Because we know that the League of Nations mandate exists and has not been abrogated. We don't know whether defense of conquest exists. Now, if you ask most international lawyers, is there such a thing as, can you conquer territory by force? For sure, the answer is no. Why? Because aggression is made illegal under Article 2 of the UN Charter. You cannot use aggression against other states. So if you're not allowed to attack other countries, of course you can't keep what you gain in these attacks. It goes without saying. Right? If you can't steal, presumably you can't keep what you steal. But does the UN Charter rule out all uses of force? No. Self-defense is an inherent right. And the Six-Day War was universally at the time thought of as a defensive war. So if the ban on conquest is a corollary on the principle against aggression, if the war is not an aggressive one but a defensive one, then it seems the corollary wouldn't follow. Now, the consensus today of the international community, a consensus which only emerged after 1967, needless to say, is no, defensive conquests also are illegal. Now, again, this is the only defensive conquest we've actually seen under the UN Charter, the arguable defensive conquest. So there's not a lot of precedent here. But it's quite clear. Now, why is it clear? Well, because you can't tell the difference between aggression and self-defense. So we're worried that countries will commit aggression, call it self-defense, as a pretext for conquest. That's the argument. It's a policy argument. It's not a precedential argument. It's not written down anywhere. It's a pure policy argument. As a policy argument, it seems singularly weak. Because if you can't tell the difference between self-defense and conquest, we have a lot bigger problems here than the Golan Heights. Rather, the entire UN Charter is thrown into doubt. The UN Charter and its entire security mechanism presupposes that there's something called aggression, which is illegal and can be responded to with self-defense, and self-defense, which is legal, and you can invite others to help you, and you can appeal to the Security Council. If you can't tell the difference between self-defense and aggression, the implications go far beyond conquest. They go to the very structure of the UN Charter itself. However, I don't want to sell this too much either, right? Because while it's quite clear that there's no rule against defensive conquest, because there was no place for a rule to emerge. If a rule is at least connecting 2 points with a line, we've only had 1 point, and a particularly politicized one. But I can't say that defensive conquest is legal under international law for the same reason. There's only that. So what's the answer? There is no clear rule of international law. Now, there is a rule of international law, believe it or not, about what to do when there is no rule. So international law actually has a meta-rule about situations in which there's no rule, which is one of the most fundamental rules of international law because it's very common that there's no rule. And that meta-rule, known as the Lotus Principle, says that unless there is a clear prohibitory rule, it's okay. And because there is such a rule in international law because international law frequently does not have rules to address particular situations. Needless to say, but I think it's fair to say that Israel's legal claim to the Golan Heights is weaker than its legal claim to the West Bank, which has going for it both defensive conquest and the League of Nations mandate. Now, it's interesting that you hear much more about the West Bank than about the Golan Heights, which suggests that maybe international law is not necessarily driving these claims. Okay, what can we see about Israel's presence in the West Bank? One point I want to stress. Whatever one thinks of the two-state solution, and let's assume, along with the Israeli government, that it's a great idea, to say that the 1949 armistice lines should be the presumptive legal basis for such a solution is simply to retroactively ratify the illegal pan-Arab aggression against mandatory Palestine. Right? Arab nations invaded mandatory Palestine to prevent the creation of a Jewish state in this territory. To say that as far as they got, that is where a Jewish state now can never be, is to retroactively legitimate what was at that time seen as clearly an unlawful aggression, and it's very hard to see why anyone would want to do that. Okay. That's the background about the territorial claims. Let's move on to settlements. So settlements is going to, and this is going to draw on some of the territorial background. First thing I want to stress is settlements is not a term of art in international law. There is no international treaty or instrument or rule about settlements. It is not an international law term. Where does the word settlements come from? As far as I can tell, the use of the word settlements is simply an adoption and translation of the Hebrew word for yeshuvim, which is a Hebrew word which literally actually means settlements, and applies to small startup communities on either side of the Green Line. It's just a Hebrew word for small town. So the word settlements is not an international law word. It's actually a word specifically about Jewish communities. International law does not use the word settlements. It uses a different word, and I think we'll see why they're characterized as settlements. Indeed, the only time, or the first time international law does use the word settlement is in the League of Nations mandate to recognize the Jewish right to settle, i.e. start small villages, irrespective of where on the Green Line, under the League of Nations mandate. So settlement under the League of Nations mandate is a good thing. Right? Jews are allowed to settle. But when people talk about settlement, they're talking about one thing. There's one particular sentence in international law which the entire argument against settlements hangs on. There's one prohibition. It's part of the Geneva Convention, Fourth Geneva Convention. And the Fourth Geneva Convention is a treaty made after World War II. All the countries of the world are pretty much members, about the treatment of civilians in wartime. A big section of Geneva Convention is about occupied territory. And then there's a particular provision, Article 49. Article 49 is mostly, the vast majority of Article 49 is about what we would call ethnic cleansing. Sub-articles 1 through 5 of Article 49 are about kicking out the population of the occupied territory, kicking them out. That's what Article 49 is principally about. There is this one sentence, which, as the International Red Cross commentary acknowledges, was thrown in as a bit of an afterthought. 49.6. If it is the case that Jewish civilians are not allowed to live in the part of mandatory Palestine occupied by Jordan from 1949 to 1967, it must be because of this sentence. This is the sentence everyone has in mind. Occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies. Shall not deport or transfer its parts of its own civilian population into the territory that it occupies. Now, note it doesn't say settle, the word settle. The verb is transfer, not settle. I think that we can learn something from that. But before we even get to figuring out what 49.6 means, we need to ask ourselves, does the Geneva Convention apply? Does the Geneva Convention apply? One might think it does not, because under the terms of the Geneva Convention, it actually addresses when it applies. It says it applies to the occupation of the territory of a high contracting party, which is a fancy way of saying the territory of a member, signatory of a signatory state. Now, what was the relevant high contracting party whose territory this would be? Well, there are only really two possibilities. One is Jordan, and no one thought this was Jordanian territory. And the other is Israel, and it seems difficult to self-occupy. So, which high contracting party is it the territory of? Now, the international legal community says, no, you're reading it all wrong. Really, the Geneva Convention is about helping people, and we want to help people more rather than less. So we're going to read it broadly in light of its policies. So what do you make of that argument? It's like any argument about reading something broadly in light of its policies. It's rather an acknowledgement that you're not reading it narrowly in light of its text. So let's say the Geneva Convention applies. Let's say the Geneva Convention applies to territory that does not belong to any country. I think this would not have been an expected result before 1967. What does the provision actually say? The occupying power shall not deport or transfer. So first, let's look at the language. Right? We're going to look at the language of the provision. We're going to look at the history of the provision, the legislative history, the background, the problems it was responding to, and we're going to look at other cases in which it was applied. In other words, we're going to do the simple and natural process of figuring out what a rule means, like we do with any other statute. What's the text say? What were the policies motivating it? Let's look at precedents and how it's been applied in other cases. I think we would do this if we were interpreting any statutory or regulatory provision. Shockingly, this exercise has never actually been attempted for Article 49.6. So we are amongst the few to engage in this exercise. So what's 49.6 mean? So I would say transfer. What's the plain language meaning of transfer? The government shall not deport or transfer parts of its own civilian population into the territory it occupies. So first let me explain, how does the international community want to read this sentence? In the reading of this sentence by the international community, any movement of Jewish civilians into the West Bank would be illegal. Whether they go themselves, if they return to houses they owned before the Jordanians kick them out, if they buy houses from Arabs, if they move themselves, under any circumstances. So the international community wants to read this sentence as saying the occupying power shall not deport or transfer parts of its own civilian population, and if they shall make it difficult for them to access the occupied territory, shall prevent them from going, and if they get there, shall make it difficult for them to stay, shall remove them. That might be a good rule, but it doesn't seem to be what it says. So does transfer apply to Jews simply building and buying houses in the West Bank? Now, the plain language of transfer would seem to suggest, first of all, who can violate 49.6? Yeah, let me start with this point. Who can violate 49.6? Only the government, the occupying power. This is not supposed to be a restrictive covenant imposed on private land transactions. It applies purely to state action. Purely to state action. It says nothing about, this is not an immigration provision, this is not a border control provision. The government cannot do this. Well, what is the thing that it cannot do? Transfer. What's transfer mean? Take people from place A and move them to place B. You take them from one place, you move them to another. Same with deport. You take them, you move them. Now, it seems that the international community, in interpreting this, has taken a page from Mitt Romney, ironically, and supports a view of self-deportation or self-transfer, but that's hard to see that that's what the provision could mean. Transfer, you take people, you move. Now let me give you an example. People say, but the government builds the roads. The government makes roads. Now it is the obligation of an occupying power to make roads and take care of all the normal aspects of life in the occupied territory, to administer this. But let me give you an example. If I drive from New York to Chicago, has the government transferred me to Chicago? It's built the roads, it's provided the police, right, so I don't get, bushwhacked on the way, provided security, very nice highway, originally created for security purposes, right? With so many analogies, the interstate highway system. It would be ridiculous to say that because the government has a highway, that it has transferred me. Right? What about the fact that if I'm in New York and I buy a house in Chicago, and the government's giving me a home mortgage discount, a home mortgage tax credit? Has the government transferred me to Chicago? It would be a very unusual use of the word transfer. Very unusual. Now, 1/3 of the population of the West Bank, maybe, a third, a half, has been Jewish population, was born there. Were they transferred? They were delivered. Again, this takes extreme liberties with the word transfer. Now, let me demonstrate this textual point by reference to some parallel provisions. There's a very big argument about 49.6. Actually, yeah, so let me show you some parallel provisions. This is not the only place in which the Geneva Convention uses the word transfer. Right? So if I was a lawyer, which I'm not, and I wanted to know what a word meant in a treaty, I would look at how it's used elsewhere in the treaty. Remarkably, this exercise has never been undertaken by international lawyers. It's never been done. Take a look. Transfer in Article 5. Protected persons shall not be transferred to a power which is not a party to the convention. In no circumstance shall a protected person be transferred to a country where he or she may have reason to fear prosecution. Article 127. The transfer of internees, excuse the spelling, the transfer of internees. Protected persons shall not be transferred. In all these cases, it's clear it refers to concerted, coordinated, organized government action. The government's taking these internees and moving them, not the government allowing them to go somewhere. In no circumstance shall a protected person be transferred to a country where he or she may have reason to fear persecution. Are we to understand that to mean that a protected person is not allowed to go somewhere where they would fear persecution? Then they wouldn't be going there in the first place. So transfer refers to organized, if not forcible, then at least centralized government action of actually taking people and actually moving them from place A to place B. That's clearly how it is used every other time in the Geneva Conventions. And frankly, I said that the international consensus is against what I'm saying, but maybe on some level the international community agrees with me. Subsequent to the entire debate over what transfer under the Geneva Conventions mean, the International Criminal Court statute was adopted. And the International Criminal Court statute, it defines various crimes, genocide, and so forth. One of the crimes in the International Criminal Court statute is war crimes. Now, for war crimes, they don't just make up a new definition of war crimes. They rather incorporate, they simply cut and paste the definition of war crimes from the various Geneva Conventions. Right? You have a perfectly good Geneva Conventions, everyone agrees to them, so let's just cut and paste. And they cut and paste Geneva Conventions 3 and 4 into Article 8 of the International Criminal Court Charter. They make just one change in the entire corpus of war crimes at the suggestion specifically of Arab countries. And this is why Israel did not sign the charter. They changed the provision corresponding to 49.6 to the transfer directly or indirectly. Ah, now we're getting somewhere. That's exactly what 49.6 doesn't say. Maybe if it said that, it would be a little closer to the international community's reading. I still think it would be a little not so close, but maybe that's more like it. And that actually rather emphasizes specifically what's missing in 49.6. It's how they want to read 49.6. Now, Israel is not a party to the International Criminal Court, so it is not governed by those provisions. Okay, so that's the question of transfer, the meaning of the word as we see elsewhere in the Geneva Convention, in its natural meaning, and as it's used elsewhere in other international legal instruments. Now, why do we have this rule? What's this rule supposed to be about? Article 49.6 is about the follow-up to violations of Article 49.1. That is to say, as the drafting convention made clear, and as the International Red Cross commentary further notes, 49.6, the entire Article 49 was in response to German colonization practices in Ukraine and Poland. So what would they do? They'd kick Ukrainians and Poles out, and they would move Germans in. Nazi colonization of Poland. Now, the first question to ask is it possible, colonize is the term used by the International Red Cross commentary, can a people colonize an area which the League of Nations has reserved for settlement by them based on their historic connection to it? You colonize places to which you don't have a historic connection. I think that's almost the definition of colonialism. So can you colonize a place to which you have a historic connection? Okay. What was wrong with it? So what was the characteristic of these German settlements? That the transfers worsened the economic situation of the native population and endangered their separate existence as a race. This is the ICRC commentary. And that's a crucial point. That is to say, the point of these was to change the demographic composition of the target population. And that's why it was done in a company with it was done together with kicking them out. It's very hard to do this if you're not also kicking out the people at the time. The goal was to change the demographics of the area. Now, Israel has never had such a goal. All the settlers in the West Bank are at most 20% of the population. And indeed, if anything, the Palestinians have flourished as a separate race since 1967, having, for example, being recognized as a separate people for the first time. Now, here's the important point that arises in the Red Cross commentaries. Again, forgive the spelling error. So they say the following thing. The Red Cross points out that if you look at Article 49.6, it just says transfers. And if you look at Article 49.1, it says individual or mass forcible transfers. And what the Red Cross is saying, because it doesn't use the word forcible in Article 49.6, it does not refer to gunpoint transfers. Okay. What people want to make with this one particular observation by the International Red Cross is that it thus applies, they create a false dichotomy. They say, since it doesn't apply to gun to the head, since it's not just about gun to the head transfers, it applies to any transfers. It applies to any movement of individuals. Now, the opposite of gun to the head in the world of state action is not voluntary private movement. It's ordinary, not gun to the head state action, like when a country engages in a project in which it organizes and coordinates an activity. That is to say, consider Article 45. Right? Article 45 did not have the word forcible in it. But clearly it refers to organized, coordinated picking up and moving. And while these things don't have to be forcible, they still have to be actual transfers by the government. That is to say, the government has to be taking people and moving them around. Note another difference between 49.1 and 49.6, which the Red Cross chose not to comment on. Clause 1 of Article 49 says individual or mass forcible transfers. When it comes to kicking people out, you can't even kick out one person. But when it comes to moving people in, it says the occupying power shall not deport or transfer parts of its own civilian population. In other words, it does not speak about the movement of individuals of their own accord into the occupied territory. Now, why would you make such a distinction? Well, as a policy matter, why distinguish between, why adopt? What would be the reason to distinguish between organized government-coordinated action and movement of people based on their own preferences and desires? The reason is really scale and effect. Actions by the government are going to be larger, quicker, and much more dramatic than various uncoordinated actions of private individuals. Now, let me say another word about the German example. It was clearly a response to German colonization. And one useful thing to know, if you're wondering, well, what did they have in mind? What was German colonization like? What was German colonization like? Again, this is not a question which international legal scholars have asked, much to my surprise. If you want to know what they had in mind, what does transfer mean, and you know the paradigmatic case were German transfers, what were these transfers like? So let me tell you what they were not like. Germany did not take out an ad, German individuals, there was no German Gush Eminim. There was no German private settlement movement that said, hey guys, let's go settle the, I guess not hilltops, but the fields of Poland. And the German government said, okay, we won't get in the way. Rather, the German government picked certain groups of Germans from various places, rounded them up into kind of central camps, gave them various tests to figure out who was the most German, picked amongst those, gave them classes in Polish agriculture and how to farm the lands that they were going to, trained them in particular for these purposes, and then, yes, put them on a train and took them to those places. They put them on a train and took them to those places. That's what the German transfer looked like. It wasn't some German guys buying some houses from some Polish guys. It wasn't some German guys moving into houses the Polish guys had run away from. The German government taking them, concentrating them, and then putting them in particular places. Let me give you a particular example which I think is very telling. Again, this has never been discussed in the international literature. You're hearing some cutting-edge stuff. Consider the difference between the commentary on the ICRC commentary and all the commentary on the Geneva Convention. So this was about the colonization of Poland, Ukraine, German colonization efforts. That's what it was a response to. Were those the only places that Germans moved to? No. After the German conquest of Europe, some Germans moved to Paris because it's a nice place. Some Germans moved to Prague because it's a nice place. Germans moved to all sorts of places under German occupation. Now, not as many of them moved. It was not as coordinated an effort. Nobody thinks that Article 49.6 was designed to stop that horrible thing that happened during World War II, that some Germans moved to Paris. No. So that's the question, if 49.6 was in place, were Germans moving to Paris, buying apartments, flats in Paris? Would that have been a violation? No one, after 1949, thought that that was what Article 49.6 was about. So the distinction, clearly, no one said that Article 49.6 was a response to Germans moving into occupied territory. No, it was a response to the German colonization program in Poland and Ukraine. That's a vastly important distinction, it seems. And people who talk about this generally know very little about the German colonization program of Poland and the Ukraine. So that's the history. And the history seems to map very poorly onto the use of 49.6 as a general prohibition on nationals of the occupying power entering the occupied territory. And then, finally, let me talk about how this has been applied elsewhere. That's probably the best thing, right? Let's say that we can't agree what it means. It's an ambiguous provision. Who knows? Who knows what the German thing was like? Unless you've taken a particular interest in this, you might think that Israel and the West Bank is the only occupation of anything, anywhere, and the only settlements anywhere. By the way, so just to clarify my previous point, I think the reason that the international community wants to refer to them as settlements is because it would be a bit awkward to say, we condemn the transfer of Jews to the West Bank, or we condemn apartment construction by Jewish transferees to transfer more of themselves into the West Bank, because it just doesn't sound right. Where's the transfer coming? So when the international community wants to condemn, some people want to build some new houses for themselves in Efrat, to say, we condemn the continued transfer. It just doesn't quite sound right. So I think that's why they use the word settlement. So thank God we don't need to figure out what the word transfer means based solely on the highly politicized context of Israel and the West Bank. Thank God there have been many other arguable cases of transfer of civilian populations into occupied territory. And we can learn from them. This is a research project, by the way, which it's an ongoing research project of mine. It's going to hopefully result in a long article or a book. I received some great assistance on this from the great Dana Bruska, an associate at Wachtell, who was a former student of mine. So it turns out there's a ton of these, and I've organized them in a particularly interesting way. So the first few are transfers into an occupied territory which previously had no sovereign. So that is a very close analog to our current situation. So Indonesia, when it conquered East Timor, there was no sovereign in East Timor. It was very similar. It had been a Dutch colony. The Dutch bug out. It's supposed to gain independence. It never does. Indonesia conquers it. Same with Morocco and West Sahara. West Sahara was supposed to become an independent country when Spain left, but the Moroccans conquer it before that could happen. Let me just tell you an interesting fact about the Indonesian settlement program in East Timor. It was massive. And it's exactly what a settlement program would look like. They took Balinese farmers. Balinese is the majority Indonesian ethnicity. And in Indonesia, Indonesia is a big multi-ethnic empire, basically. And they had a long-standing policy of moving their people around to islands with different ethnicities. And when they conquered East Timor, they continued to apply this Balinization process. They would take Balinese farmers. They would take them to a camp. They would teach them how to farm in East Timor. They would give them some money, and then they would take them on a boat and actually move them to East Timor. What did the international community say? They gave them a World Bank grant for economic development. Morocco, the majority of the population of Western Sahara now is Moroccan settlers. Now, when you're talking about Morocco and Western Sahara, Morocco probably did transfer them, because you can't just really get from Morocco to West Sahara so simply by yourself. Perhaps the closest example, the closest analogy is Jordan and the West Bank. Well, what did people say about Jordan and the West Bank? Now, not many Jordanians moved to the West Bank because it was poorer than Jordan. Mostly the movement went the other way. But there were some projects. So, for example, the king of Jordan started building himself a palace in Jerusalem. Nobody said illegal settlement construction. You're the king of Jordan. How can you build settlement for yourself in Jerusalem? Nobody said illegal settlement construction, and that's a very close example. Now, recently, William Hague, the Foreign Secretary of Britain, he said something I thought quite remarkable. He spoke to why they care so much in Europe about Israeli settlements. I found it remarkable that he chose to speak to this because it seems to recognize that it's a question that begs an answer. And he said, well, because it's very close. It's a violation of the Geneva Convention. It's right next to Europe. We're Europe. They're right next door. So it can be a problem for us. Now, Turkey in 1975 invaded Cyprus and continues to occupy it to this day. The majority of the population of northern Cyprus are Turkish settlers. Now, Cyprus is not just geographically closer to Europe. It's in Europe. There was a resolution proposed in the European Parliament that did not pass, condemning Turkish settlement activity. That's as close as we got. Okay, now what's interesting about all of these examples, or many of these examples, so let me give you the bottom line here. The bottom line is, in none of these cases did the General Assembly or Security Council suggest a violation of Article 49.6. In not one of these cases. More importantly, what we hear in the international community is, if 49.6 is violated, what's the remedy? The remedy is all the settlers have to be kicked out. That's actually how I started this project. I wondered, where do we get this idea that if it's illegal, ab initio, then the remedy is the removal of all those people. So in the case of Indonesia, Morocco, Turkey, and Vietnam, there were internationally sponsored, UN-backed peace proposals to resolve the underlying conflicts. Most of them didn't work out, like in Morocco and in Turkey and in Morocco and Turkey, but some did in Indonesia and Vietnam. In all of them, the question of the settlers was raised. They said the same thing the Palestinians said. So the Cambodians, at the end of the War of Vietnam, in the Paris negotiations in 1999, one of their demands was not just that the Vietnamese army leave, they say you have to take these Vietnamese with you. We hate them, we can't abide them. We'll never have peace if the Vietnamese, if the ethnic enemies stay. Enemies and Khmer just don't go well together. And the response of the international community said, you can't say things like that, that's racist. That's you can urge that the military leave, but you cannot demand that the people leave. In none of these cases were the settlers required to leave, and in most of the cases, the settlers were actually allowed to vote in a future plebiscite on the territory's future. Note that one of these occupying powers of settlements is Russia, notable for being a member of the Middle East Peace Quartet. Now, again, one thing to notice, these numbers of how many, so we have the number of settlers there and then the percent of the population in the territory that they constitute. You'll see that the ranges are huge. Right? Like in Lebanon, 300 to 400,000, and that's just the middle of the range. Estimates of Vietnamese settlers in Cambodia vary by hundreds of thousands. And really, the reason there's these gaps is we don't have a piece now in these countries documenting each and every individual who goes there. But what I would really like to stress, I think the example of France is very important. France was one of the winning powers of World War II. Were central in drafting the Geneva Conventions. And we're actually drafting the Geneva Conventions. Everyone knew that the winning powers were actually going to take some German territory and Italian territory, and they were very concerned that their actions not be illegal. And they asked some questions like, surely this doesn't mean like our occupation of Germany? No, that kind of stuff is okay. It doesn't apply to all occupations. That was the answer. And France exploited and controlled the Saar, a very wealthy area of Germany, well into the 50s. No one suggested there was any Geneva Convention issues. Okay, finally, what I would say is, I want to object basically. If you take nothing away from this, I think the word settlements is not useful. Because the word settlements assumes that all Jewish civilian presence in this area would have the same legal status by virtue of it being a Jewish civilian presence. If there are violations of international law here, it is because, maybe, perhaps, and I wouldn't argue in certain cases, certain actions of the Israeli government would be said to amount to transfer. This is strong. You could, for example, argue that when they take Russian immigrants and send them to places in the West Bank, maybe that was transfer. But it is impossible to speak of the legality of settlements overall. Right? The settlements are not a legal entity. The prohibition is on the movement of people. Some people could be transferred, other people could be not. It's actually a very fact-specific situation. But no one is actually interested in this. And the point I'll leave off, which I think illustrates how no one is really trying to look at Article 49.6 when they construe this. What's the worst kind of settlement? Worst kind of settlement is an illegal settlement. What's an illegal settlement? An illegal settlement is one which has been built without the permission of the Israeli government. Now, it's important to note, almost all of the controversial settlements started as illegal settlements. Hebron, Shiloh, Ophrah, the most controversial settlements did not start by Israel saying to people, this would be a good place for you to settle. Rather, people went there, they settled, the army came and kicked them out. They came back, army kicked them out, they came back, army kicked them out. Finally, the army said, we're going to go do something else now. Now, how that would be a transfer is hard to understand. But there are still wildcat settlements, which have not been subsequently ratified by the Israeli government. And those are considered the worst settlements, the outposts. Right? Because people there are weird and they're pretty far right. So it would seem if there was any settlement that would be legal under international law, it would by definition be the ones that are illegal under Israeli law. So the illegal settlements, everyone should love the illegal settlements. When these kids go up on the hill and build a little camp, what's the Geneva Convention have to do with it? The illegal settlements should be the legal ones. Now nobody makes that claim. There's no international lawyer that says, yes, the settlements are illegal except for the illegal ones which are legal. which again suggests that this is not about transfer, but rather about the Jewish presence in this area under any terms. Okay, thank you, and I eagerly await your questions. And that's my contact information. Okay. Yes, ma'am.
Yes, the Edmund Lee report that just came out this past year seems to have been a very careful study by a very unrecognized legal body that says that there is no such thing as legal settlements. And because of that, there's now a big effort to apply sovereignty to Judea and Samaria. So, what are your comments on that?
It's a political question. Well, the question is, should Israel annex the West Bank? Maybe yes, maybe no, but that's a political question. I think Israel would be within its rights to annex at least Area C of the West Bank, which under the Oslo Accords has been left under exclusive Israeli control and where 100% of the settlements are. Sam, you had a question?
No, I comment on the legal report. You recognize that it's valid.
I have not read all of the Levy report because they have not translated it all into English. I think the Levy report has some good arguments and some bad arguments. Most of the Levy report is not about the international law issues, but rather about underlying private property issues surrounding who owns particular parcels of land. And that gets into issues of municipal zoning and private property law, which are really too complicated for me or I think most people to properly understand. But I think it's a good thing, the Levy report. It's good at least because it reopens the discussion of this issue. Sam, you had a question?
I've heard it argued, and you agree on a lot of this, you know, I've heard it argued that to make some of these arguments, they also develop Israel. Say that armistice lines now reflect boundaries. I know you got to get to League of Nations. Say the armistice lines don't count. It goes both ways. That's exactly the argument.
It does go both ways. Israel does not have a demarcated border. I think that's quite clear. And by the way, as proof of that, but we should at least take the good with the bad. That is to say, there's a reason no nation in the world, including our own great country, recognizes West Jerusalem as being in, not the capital of Israel, but rather in the country of Israel. What country it's in is a separate question. But no one recognizes it as being in Israel because specifically they don't recognize the armistice lines as being borders in a way that is detrimental to Israel. So at least it should go both ways.
Both ways that Israel's legitimacy is recognized.
Who says legitimacy? League of Nations.
I mean, it goes both ways. I'm not sure that's a position that I would want to see.
No, what goes both ways is Israel does not have finalized borders. By the way, many countries don't have finalized borders. India doesn't have finalized borders. Pakistan doesn't have finalized borders.
One difference is if you are Israel's a very small nation with a massive border, you can see that.
Oh, wait, no. I take back what I said. Wait, hold on. Yeah, the question is, like, if the armistice agreement is not supposed to be a border, then doesn't that mean that Israel doesn't have a border? Now, Israel does not have a border, but the important modification to this, Sam, that I should add, this is an armistice agreement between Israel and Jordan and Israel and Egypt. Subsequently, Israel and Jordan have signed a treaty recognizing the Jordan River as the border between them. So this point from the armistice agreement would be superseded by the Israel-Jordanian agreement. And so Israel does have a border which is somewhere between the river and the sea, and it remains to be determined where. But its border with Jordan is clearly now the Jordan River. That is to say, the point of this provision here is that Jordan can demand the rest of it. Jordan has since waived those rights. Yes, sir.
Now, what impact, if any, does the General Assembly is advisory only? But as you know, last November, the General Assembly voted to recognize the Palestinians' claim to statehood, at least as a non-member observer state status. And so now there are speculations that Palestinians will at some point approach the International Criminal Court or other bodies to declare Israel's presence on their state land in violation of international law. So how would you...
Okay, General Assembly resolution and ICC jurisdiction. First of all, I would refer you to tomorrow on the National Review website. I'll have a short article about that, ICC jurisdiction over Israel regarding the General Assembly resolution, and I have a much longer academic treatment of this available on the Social Science Research Network, an article which I recently wrote. So the General Assembly recognized Palestine as a state. And Sam, this relates directly to your question. It did not determine the borders of Palestine. So even assuming that the International Criminal Court accepts the General Assembly's finding that Palestine is a state, because Israel is not a member of the ICC, Palestine can only refer crimes that were committed on the territory of Palestine. Now, what is the territory of Palestine? We don't know. It's undetermined. And all of the settlements in particular are in the disputed portion, which under the Oslo Accords, Palestine has agreed to Israeli exclusive criminal sovereignty in Area C, where all the settlements are. The notion of the ICC is that it has a delegated jurisdiction, that countries have a territorial jurisdiction, and they pass that on to the ICC. But Palestine does not have territorial jurisdiction, even if it is a state, over Israeli settlements, because they are all in Area C, which, by agreement with Israel, they have put under exclusive Israeli criminal jurisdiction. There's also many other reasons why this would not be a case before the ICC.
The only qualification I would make to what you said is that actually the resolution that the General Assembly passed, according to this non-member state majority Katz, does mention the pre-1967 borders.
It does mention them as a frame of reference, but specifically notes, take a look at my article, specifically notes, if you look at the language, it says, we call on the parties to decide borders and settlements. Now, if borders are something to be decided, that means they're not yet determined. Now, the International Criminal Court is not a border demarcation body. That is a massive power which it does not have. Even the International Court of Justice, which is in the international boundary business, can only do so with agreement by both sides. And there's a principle in international law called the monetary gold principle, from the monetary gold case of the International Court of Justice, that an international tribunal cannot determine the rights of a country in a proceeding to which that country is not present. So given that Israel is not a member of the International Criminal Court, it would be, I think, quite impossible for them to determine Israel's borders. So,
a twofold question. While I think that this presentation is fine legally and maybe even logically, it seems to me that it misses the point in the sense that this is a public relations battle, and to a very great extent, Israel lost that battle a long time ago when it never really wanted to dirty its hands with public relations, and it basically ceded the field to the Palestinians. And second, the question of settlements is really, I think, a very overblown question, which isn't necessarily understood, because the main blocks, like the Gush, Etzion, are going to remain part of Israel if there is ever a settlement. So it's really a dispute over a very small portion of the land of the whole, and the resolution of that dispute is, what other parts of the land Israel will give up to the Palestinians in exchange. We kind of blow this out of proportion by spending so much time on this. There's got to be a better way of doing it.
Sure. Okay. Yeah.
So you were advising Israel what would be our next step politically, legally. What should we do? You've now become our legal advisor.
Well, first of all, they should be saying these things that I'm saying. There's reasons they're not, but it's impossible, by the way, it's absolutely impossible for a democracy to compete with an autocratic state in public relations, because the first basic thing of public relations is to have a message and stay on your message. But if you have a different prime minister every 2 years and many ministers and two Jews, three opinions, that's going to be hard to do. Legally, I would actively assert these claims. My pet idea, if anybody wants to be involved in this, I think the best way Israel could underscore the point about the International Criminal Court and weaken the dialogue about settlements. I think the most shocking thing is Israel is trembling at the prospect of International Criminal Court litigation, because it would be awkward and embarrassing, they think. And where did Abbas announce his plan to take Israel to the International Criminal Court. Where did he have his press conference? In Ankara, standing next to the Turkish president, who was responsible for maintaining settlements in a member of the European Union. The European Union, a few months ago, released a position paper, a white paper, on what to do about Turkey and Cyprus. And there's nothing. Nothing. Because, you know, these guys are very Islamic and they take offense easy and we don't want to cause a stir. That's exactly what they said. We don't want to upset the Turkish government. If I were Israel, I would get our new friends in Cyprus. Here's what I would say. I would say 5 years of gas for free if you refer Turkey to the International Criminal Court. And if Turkey would be referred to the International Criminal Court, it would turn out that 49.6 only means when you actually take the people and pick them up and move them over. And that would become very clear. And Turkey would be articulating this most clearly. And Europe would be articulating this, and no, those aren't settlements. That is to say, what is the key characteristic of a rule of law? Trevor spoke about the rule of law. Rule of law is a general principle which is applied to unknown future cases. Here you have a rule of law that's only applied to one known past case and kept separate from the main body of law. I would try, for example, the Olympics are going to be in Sumy, in Georgia, which is very close to Abkhazia, where Russia is building settlements. You can go onto, no, there's no peace now. I have to research this myself, which is very annoying. But you can go onto Russian newspapers and they say, you know, recently vacated houses in Abkhazia, on the Black Sea. So if I was Israel, and they don't want to piss off Russia for a lot of good reasons, but I would say, you know, it's going to get publicity because of the Olympics. I would say, well, you know, this is 50 miles from Russian settlements. Those were some of the things I would do. Trevor. Yeah.
I have two quick questions. The one is, can you comment on the Israeli Supreme Court's statements that I think they essentially say that the Geneva Conventions do apply. Do they acknowledge that Israel, that the West Bank is occupied territory in so doing? Can you comment on that? And the other, real quickly, if you know, I think the U.S. used to have a firm position that they didn't regard settlement activity as illegal, but if prudent and in politics and don't do it, but not illegal. Is that still their current position? Okay,
so as regards to the latter point, U.S. position has varied like about 5 times. So you know, there are memos from the State Department from 1968 saying we would regard this as illegal. Under Jimmy Carter, State Department quite clearly said it was illegal. Under Ronald Reagan, they said it was legal. George Bush, in the famous Bush letter, recognizing facts on the ground, implicitly acknowledges their legality. Now the term is illegitimate. I have no idea what that means. So the position of the United States has varied considerably. Now the Israeli Supreme Court, this is an important point. Israel, when it came into the West Bank, said we will, as an act of grace, sort of go beyond the letter of the law and apply most of the Geneva Conventions in the occupied territory. And the Israeli Supreme Court simply recognized the government decision to do that, not as a matter of legal requirement, but as a being extra careful kind of thing. And I think the best proof of that is the Israeli Supreme Court in no way objects to the application of Israeli law in eastern Jerusalem, which conceptually is as much as part of the West Bank as anything, but which Israel has annexed without any protest from the Supreme Court. Yes, sir, in the back.
So, I'm persuaded by the analogy you're drawing to Paris to say Israeli buying a penthouse.
I thought of it just this morning. Thank you so much.
Okay, but I'm questioning whether, so suppose that's right about the transfer of individuals. What factor that the settlements themselves are off limits to most of the local population, or the ability to buy it or actually travel into the settlements have some effect?
No, I don't think so, because it's really purely the movement of people. The off-limitsness of the settlements, I mean, they're not off-limits. Palestinians go there for work, etc. Under the Oslo Accords, Israel and Palestine basically agreed to put each other areas off-limits to each other. So this is a combination of the Oslo Accords and post-Intifada security restrictions. But for example, in eastern Jerusalem, there are plenty of Palestinians, and they come and go. And Jews are not allowed into Ramallah either. And this is a result of security. But in Israel, this is considered a legitimate, you know, there are Arab villages and there are Jewish villages. And the associational freedom is thought to protect this kind of thing. Yeah, we had a question. Yeah, you had a question?
Yes, under international law, is there a definition of occupied territory?
No. I mean, the definition of occupied territory is the territory of a high contracting power. What makes it occupied? It's when foreign armed forces are in it. That is to say, if the West Bank was the territory of a high contracting power, Israel's presence would be an occupation. Occupation is when an army comes in, yes, until peace is made. Arguably, by the way, even if it was an occupation, the Oslo Accords end the occupation, because occupation only lasts until some other system is set up in place, and Oslo is clearly another system. Yeah?
Could you explain the difference between international law and customary international law?
Customary international law is one of the sources of international law. Customary international law basically states that the rule is like this. The meta rule is countries can only be bound by their consent. If there's a universal practice that countries engage in with a sense of legal obligation, not just because it's convenient or out of force of habit, that could become evidence that they're actually adhering to a rule. Now, custom used to be much more common because it was hard for everyone to get together and sign treaties. Now, almost all custom has been codified into treaties, or treaties are just generally the go-to thing now. Custom was much more useful when it was hard to fly everyone to Turtle Bay or Geneva, and has now been largely supplanted by. But custom, it's a binding minhag. Okay, one more question from this side of the room. Okay, from this side of the room. Okay, thank you guys so much. Really appreciate it.